afternoon, everyone. Welcome to our webinar, Advanced ERISA Compliance Review. My name is Amanda, and Larry Grigine will be your presenter today. This is Larry's specialty, so I know we'll have a lot of information to get through. Don't worry if you don't catch everything. We're recording the webinar, and we'll email you the video and the slides after the webinar ends. Our next webinar is on October 25th at 1 p.m. Central Standard Time, and we'll be covering health savings accounts. We have a lot of participants today, so I'll be keeping the conference on mute. Larry will pause for questions periodically, and I'll unmute you so you can ask them. If you prefer, you can also type them in the question box below, and I'll answer the questions for you. Other than that, please enjoy.
Thank you very much, Amanda. I appreciate it. The reason why this is important because it affects most benefits provided to employees. What I'm going to try to do today is explain when ERISA applies, what benefit applies to, and then if you have an ERISA benefit, what do you have to do in regard to documentation, disclosure, claims, and also fiduciary duty. These areas are real important. And the reason why this seminar is extremely important, because for some employers there's a misconception that if you have under 50 employees, ERISA doesn't apply. Well, ERISA does apply, but the 5,500 or under 100, a 5,500 requirement doesn't apply. So under the 100 situation applies just to the filing of the 5,500, but the rest of ERISA applies. So in this situation, first of all, I'm going to ask who must comply, and basically every private sector employer must comply with ERISA. So that includes corporations, partnerships, sole proprietorships, and also it includes non-for-profits. So if you're not a governmental entity or a church, you have to comply with ERISA. And ERISA applies if you are offering your employees certain benefits. So even if you have one employee and you offer that employee benefits, then that's when ERISA does apply. So why is it important to determine if an employer sponsors an ERISA plan? And I think the important term here is sponsor. You have to sponsor a plan. But if it's determined that you have an employer-sponsored plan, then all the requirements of ERISA come in. But there's some benefits for having an ERISA-sponsored or an employer-sponsored ERISA plan. The advantages of the employees and beneficiaries may not sue in state court, and if you make certain decisions, either you as an employer or their insurance companies, courts generally apply a more favorable standard of review in determining whether you met the requirements of ERISA. Now, and again, basically what we're talking about here, we're not talking about retirement plans here, we're talking about ERISA employee welfare plans. And I'm going to go through exactly what that means in a few minutes. Now there's, what's important to understand, basically the biggies like medical, dental, vision, all apply. ERISA does apply to those benefits, but there are certain exceptions and safe harbors. Now, to have an ERISA employer-sponsored plan, it must be a planned fund or program. It must be established or maintained by the employer, and for the purpose of providing specified benefits to participants and beneficiaries. So again, what's extremely important, it must be established and maintained by the employer. Now, if there's a planned fund or program, in determining whether there is a planned fund or program within the meeting, the courts ask whether the following surrounding circumstances a reasonable person could discern: was there intended benefits, did it benefit a class of beneficiaries, was there a source of financing, either employer or employee contributions, and was there procedures for receiving benefits. And this has been litigated. One of the most famous cases is cited there, Fort Halifax, where basically what they looked at was a early retirement plan. And what they indicated and what was important to determine whether there was an ERISA benefit was there an ongoing administrative responsibility or scheme to determine eligibility and calculate benefits. If it's a one-off type of benefit where it's limited, it's not an ongoing program. Generally, ERISA will not apply. Now, is there a fund, plan, fund, or program? And again, if this is a one-time lump sum severance bonus, there won't be any ongoing administration, so probably your bonus will not be considered an ERISA plan. And a written document is needed to create a plan, fund, or program, and one of the requirements of ERISA is that there has to be a written document. Now, what's interesting is that both under the regulations and courts don't really tell you what that document is to look like. There's no structure that is required. But again, what they will do if they determine that it's employer-sponsored and there's ongoing administration, some courts will actually create plan terms, and that's one situation that you don't want to get into where court determines what your intent is. You want to put it down on paper. Now again, under the court rulings and under the regulations, as this slide 8 indicates, an employer doesn't need much to establish a program, and generally it is resolved if they're self-insured arrangements. Usually there's more in writing on that. The issue is more uncertain if there's insured arrangements. Purchasing insurance through employer maintenance or voluntary benefits, safe harbor, that's when it gets kind of squishy and kind of uncertain. But in some situations, if an employer is sponsored, even individual insurance policies could create an ERISA plan, and I will get to that in a second when that's the situation. Now, specified listed benefits include medical, surgical, hospital, benefits in the event of sickness, accident, disability, vacation, apprentice, daycare centers, scholarship funds, prepaid legal services, holiday and severance benefits, and housing and assistance benefits. All could be considered ERISA benefits. The next requirement is, are the benefits provided to participants and beneficiaries? And who is the participant and beneficiaries? Is it current employees, beneficiaries designated by the participant, the spouse, and kids? Also, ERISA benefits could be established for retired employees. So if you have a retiree benefit, those are also ERISA benefits. Plans covering just self-employed individuals and partners are non-ERISA benefit because you have to include common law employees. And plans covering only one employee, in that situation, it must be a non-executive. Now, again, there's statutory and regulatory exceptions. These include workers' comp, unemployment, and some disability benefits are not considered to be ERISA benefits. Also, certain fringe benefit plans are not ERISA, and an example of that is a cafeteria plan. The POP section of a cafeteria plan is not considered to be an ERISA benefit; it's considered a fringe benefit. So here, and now the portion of a cafeteria plan that is considered to be an ERISA benefit is the health FSA, but the dependent care part and the POP part are not. Also, other fringe benefits could include transportation. So benefits under Code Section 125, 132 are not considered to be an ERISA benefits. They are considered to be fringe benefits. Now, there are certain statutory regulatory exemptions. This includes what we call payroll practice exemptions. Wages, overtime pay, shift premiums, holiday and weekend premiums, unfunded sick pay or income replacement funds. These are short-term disability programs. Vacation, holiday, jury duty, and similar pay are not considered to be ERISA benefits. They are considered to be payroll practices. But again, in order for this exception to apply, they can't be insured. The benefits have to be paid out of the employer general assets. Now, one of the biggest exceptions that many employers use is the voluntary employee pay all exemption, where an employer provides what we call voluntary benefits. These are completely paid for by the employee, and monies are taken out of their paycheck to pay for these benefits. So it permits employees to pay for premiums through payroll deductions. The employer cannot make any contributions towards the coverage. And the issue and problem is, and where many employers run afoul, is this next requirement. The employer may not endorse the program. This includes selecting insurers, negotiating terms or designs, linking plan coverage to employee status, using employer's name, recommending plan to employees, and doing more than just permitting payroll deduction. And a good way that an employer can blow this exemption right here, and what is seen as an employer endorsement, is allowing employees to pay for those benefits under a cafeteria plan with pre-tax dollars. That would blow this exemption. So again, many employers provide voluntary benefits of various types. It could be dental, vision, it could be additional life insurance, AD&D. All those can be voluntary benefits. But again, you have to be very careful to make sure that you come under this exception. And many employers blow the endorsement portion of it because they recommend the program to the employees. They pick the insurers that come in. So you got to be very careful, because if you meet the requirements of this exemption, then the benefit provided under that plan or under that program is not considered to be an ERISA benefit. Now, other miscellaneous exemptions include facilities on the premises for employer to provide first aid or treating minor injuries, tuition and educational expense reimbursement programs, and remembrance funds providing flowers or small gifts. So those are not subject to ERISA. So again, you can look at this as we move forward, and when you get a copy of the slides, this is a kind of a list of exactly what benefits are and are not considered ERISA benefits. And again, the major ones are cafeteria plans. This is the POP section. Again, DCAPs are not. Adoption assistance are not. They're considered to be a fringe benefit program. And then short-term disability program, you have a choice there under short-term disability. It can be a payroll practice, but in order to be a payroll practice, it cannot be insured, it has to be self-insured. And again, voluntary insurance, if you meet the requirement of the exemption, you can not be subject to ERISA. Now, when you're talking about ERISA, you have to understand these certain terms, and these terms always come up in discussing with employers and also with employees. So an ERISA plan is, again, subject to ERISA. The plan sponsor is the employer. ERISA plan administrator, this, in most situations, is going to be the employer or somebody picked by the employer. This is someone who has fiduciary duty under the plan. And generally, it's not the insurance company. Participants and beneficiaries are the employee, their spouse, and dependent children. And generally, in all documentation, under ERISA, under the plan documents, you have to have a named fiduciary. And most employers name themselves. It could be the head of HR or administration, could be the name. This is someone designated as the top fiduciary who has discretion under the plan. A fiduciary has discretion under the plan. Now, what many employers don't understand, yes, there's one named fiduciary, and they'll have to be named in the plan documentation. But there's other, which we call functionary fiduciaries. These are individuals that work for the employer that has discretion under the plan. They may be negotiating insurance benefits. They may be assisting in administration of the plan, and they have discretion under the plan terms. So any corporate officer that has discretion in deciding what the benefits are and how they're administered could be an ERISA plan fiduciary. And what's important about that is the fact that if there are any issues or problems with the plan, any ERISA fiduciary could be held personally liable. So that's why it's important to identify these individuals, make sure they understand what their role is, and make sure they get additional coverage for those individuals because they have additional liability. And then you have a third-party administrator who many times for self-funded plans, either a cafeteria plan, health FSA, an HRA, these are individuals that will administer the plan. Now, they could be a claims fiduciary. In most situations, they're not an ERISA plan administrator. They could be a fiduciary if they're named that, and many times TPAs are what we call claim fiduciaries because they have final discretion of who receives benefits under the program, and they will decide the final appeal. And as an employer, you can designate that. But again, many times they're not the ERISA plan administrator. So here are the key ERISA requirements. You have to have a plan document for every benefit or every plan. Plan terms must be followed. That's one of the requirements for ERISA. The strict fiduciary standards must be followed. And this is similar to a trustee under a trust. Fidelity bond may be purchased to cover every person who handles plan funds. And when you have health and welfare plans, in most situations, unless you create what we call a voluntary beneficiary association, a VEBA, many times benefits are paid out of corporate assets, and there's no actual plan funds like there are under retirement plans. Summary plan descriptions must be furnished automatically to plan participants. Summary of material modifications must be furnished automatically to plan participants if the plan is amended. You have to make sure the employees keep up with the plan terms. And copies of certain plan documents must be furnished to participants and beneficiaries upon request. Now again, the summary plan description, and many times when I talk to employers, they don't understand that there's a requirement under ERISA that those have to be provided. And I'll be talking about that in a few minutes. So you can't just make it available. It must be provided to participants. You must give them a copy, either electronically or in the mail, or hand deliver a copy of the summary plan description. Also, 5500s must be filed annually. Again, there's a special exception for small plans, but please be made aware there are, again, suggested changes in the future, 2018 or 19, that may eliminate that small plan exception. A summary annual report must be, again, summarizing the 5500. Information must be provided to plan participants and the plan who files the 5500. There must be claims procedures that must be established and carefully followed. Plan assets, including participant contributions, must be used only to pay plan benefits and reasonable administration fees. If monies are held in the plan's name, it's recorded under ERISA that these actual plan assets must be held in trust. And again, there are a number of different mandates, such as COBRA and HIPAA, that group medical plans or health plans must comply with. So it's a myriad of different mandates that an employer must follow. Plan document requirements. ERISA does not require benefits to be provided and applies only after the employer undertakes to provide benefits. So again, there's nothing in ERISA that requires an employer to provide benefits. But once you do, then there has to be documentation on what those benefits are. The plan design decisions are generally not subject to fiduciary rules, and ERISA imposes few restraints on plan design. Again, it doesn't have to be a formal plan document. Many times there could be a combination of plan document and SPD, but again, it has to be in writing. So, and again, plan must be established and maintained through a written document. So every welfare plan must be established and maintained by a written instrument. A written documentation does the following. Participants are on notice of benefits and their own benefits under the program, and it provides the plan administrator a guideline of exactly how to provide the benefits to the participants. So that's why they encourage as much writing as possible. But again, I just want to stress that ERISA does not provide any specified format or content. They give suggestions, but again, is basically, and what's important here is that the insurance contracts are not ERISA documents. They come close in some situations. That's why many times employers use wrap documents that fill in the blanks where the insurance contracts don't cover all the requirements. So again, as this says, the wrap document fills in the missing ERISA requirements. Now, what are the consequences of a failure to have a plan document? Well, there's no specified penalties for not having a plan document. But the employer cannot respond to written participant requests. Benefit lawsuits may be based on past practice and similar evidence. It could be plan terms could be set by emails by the HR department. If there's nothing in writing, there could be less favorable standard review for benefit lawsuits. Since there's nothing in writing, they may not take what the plan administrator or the insurance company says. There's limited ability to amend and terminate plans. And it puts the fiduciaries, the people with discretion, the corporate officers, they're having a tough time follow the plan terms because nothing's in writing or very few terms are in writing. So it gives them, they're at a disadvantage in making sure that everything is done properly. So plan document compliance issues with insured benefits, insured plans. Again, the insurance contracts don't contain all the terms that ERISA requires. Now, what you can do is you can bundle various benefits in one wrap document. It's possible. And a single document can serve both as the plan document and SPD. And many times when you provide more than one benefit, the use of a wrap or umbrella document can satisfy the written documentation requirements for all these benefits in one document, which makes administration in compliance. And these wrap documents become popular because more and more there's DOL audits, and one of the things they're looking at is written documentation. Now again, these are all the plan terms that should be in there. For example, there has to be named a named fiduciary, procedures for allocation of responsibility, funding policy, how payments are made, claims procedures, amendment procedures, distribution of assets on plan termination, required provisions for group health plans, and what's listed there is all the different mandates that have to be in there. In some or all of those may be in the insurance contract, maybe not everything. If you go towards the bottom, there's a QMCSO, Qualified Medical Child Support Order. It's required that the employer has procedures to deal with those, and sometimes the insurance contract may have some provisions in there, but not complete. So you got to be real careful in that. And again, optional plan provisions could include fiduciary functions, designating who the different fiduciaries are. Other important plan provisions, permission to use plan assets and to pay for administrative expenses, incorporating provisions that appear in the SPD, eligibility requirements, benefits requirements, exceptions, provisions required by other laws, including family and medical leave, and how the plan should be administered. And again, other general terms, what state law applies. There's no contract of employment, no guarantee of tax consequences. Other important plan provisions include discretionary language in regard to court review, subrogation, language regarding exclusion of independent contractors, and whether assignment of benefits are permitted. Also, another provision in there is how the employer will use any medical loss ratios, rebate payments in that regard. So again, it could contain a lot of these different benefits. Now again, what's important here is that anyone who is designated as a fiduciary, as this slide indicates, is the fact that if you have discretion under the plan and you are a fiduciary, you basically are held to a very high standard of responsibility, similar to a trustee under a trust. So you have certain, again, standard of behavior. You can't self-deal. You have to make sure you administer the plan for the benefit of the participants and beneficiaries. So this is extremely important, and anyone who breaches their responsibility will be held personally liable for any damage, for any loss of benefits that any employee or beneficiary may suffer. So again, this is extremely important. And again, there's automatic beneficiaries, anyone who's named a fiduciary on the plan document, plan administrators, trustees, and again, but what's troublesome is that if you have any corporate officers that have discretion of the plan, they could be deemed to be what we call a functional fiduciary that could be held to the standard. And that describes it right here, what functionary fiduciaries are. Anyone who has discretionary authority or discretionary control over how the plan is managed, have authority or control respecting management or disposition of plan assets, render any investment advisor, have any discretionary authority or discretionary responsibility in the administration of the plan. That could be any corporate officer, for example, who has discretion in picking insurance companies to provide benefits. So again, if you're a fiduciary, you have a great standard of behavior. So the duties of care and integrity imposed on fiduciaries have been one of the highest, if not highest, in the common law. In enacting the ERISA fiduciary duties, Congress intended to incorporate principles of common law trust tailored as necessary to employee benefits. So again, please understand, and when I talk to employers, this is something I really stress the fact that you have to make sure you understand what the responsibilities are. Now, here's what the principal duties of a ERISA fiduciary are. To act solely in the best interest of plan participants, to use plan assets for the exclusive purpose of paying plan benefits, to act with skill, care, skill, and prudence and diligence that a prudent person, would have similar circumstances would use, to diversify plan assets, and to act accordingly with documents governing the plan. And that last one, again, if you don't document what the benefits are, puts any fiduciaries in danger. And again, prohibited transactions. ERISA Section 406 prohibits certain listed transactions, and basically it's between the plan and what's called a party in interest, which is and the plan fiduciaries. And these listed transactions result in an abusive status by a fiduciary. And these are the basically prohibited transactions. Now, in this situation, basically what these rules indicate, and the most important one is that a fiduciary cannot self-deal with the plan, cannot make money off the plan. So they cannot sell or exchange or lease any property between the plan and the party interest, lend money, furnish goods or services, transfer, use, buy, or for the benefit of party interest any assets, or the acquisition on behalf of the plan of any security real estate in violation. So again, they just want to make sure that anyone who has discretion under the plan has the plan participants in the best interest and not making money off the plan. So again, you can't deal with assets as their own. You can't act in any transaction involving the plan on behalf of any party whose interests are adverse, and you can't receive any consideration for his or her personal interests in a party dealing with the plan. So again, they want to make sure that the fiduciaries have the interest of the participants at heart. So again, as I indicated before, and this is another important slide, is that if your individual is deemed to be a breach of fiduciary duty, then you are responsible for any losses, and that liability includes personal liability for losses caused by the plan, personal liability to restore the plan any profits the fiduciary made through the use of plan assets, or any equitable primitive relief as the court may deem. In other words, individuals or participants may force you to do certain things that are required under the plan if you're not doing them. Now, there's a bond that's required. The amount is at least 10% of funds handled during the prior year, minimum of $1,000, the maximum of $500,000. Now, if there are any breach of fiduciary duties, there's a program that is called the Voluntary Fiduciary Program, Compliance Program. Program covers 18 specific fiduciary breaches, and basically what you do in this program is go to the DOL, confess your sins, correct the situation. The correction is then documented. You send the application to the DOL, they bless it, and what happens in that circumstance, if you're ever audited later, there won't be any breaches for that particular violation. All right, let's stop right there. Amanda, I've been going on for a long time. I'm going to stop right there.
Alrighty, we don't have any text questions, but I will unmute so that anybody who has them can ask them.
The conference has been unmuted.
Does anybody have any questions?
Senator Tanya. Thanks.
Anybody have any questions?
Would we be able to get a copy of this presentation?
Yep, we'll be emailing
You'll get
the
a copy of the
slides.
presentation, you get a copy of the recording. So again, they'll be sent after the seminar. So sit back, relax. You're going to have a chance to get a copy of everything. So it'll be sent to you.
Yep.
Okay?
Thank you. Thanks, Larry.
Anything else? All right, why don't you mute everybody and let's go on. Now, this next slide.
The conference has been muted.
Very often recently, and basically what this is, if you have any type of welfare plan, and if you invite any unrelated employer to participate in that plan with you, for example, if you let independent contractors participate under your welfare plan, or if you have a number of different companies, they're not really a control group, but they have some ownership interest, but they don't rise to a control group, but you're covered under one medical program, that you created a MEWA. And what's important about a MEWA is that because of things that happened in the 80s and 90s, what the government did, what the federal government did, is said, if you have a MEWA, and these are programs that include more than one employer, unrelated employer. What happens is those are regulated by the states. Each state has different rules in regard to that. Some states only allow MEWAs to be organized by associations. Others prohibit them. For example, in the state of Illinois, you can only have insured MEWAs. You cannot have self-insured MEWAs. And there's additional filing requirements besides the 5,500. Also, the small plan exception doesn't apply in that situation. Also, you have to file an M1. And so there's different compliance issues when you invite other unrelated employers to participate. So instead of just federal law applying to you, you also have state rules that apply to you. So please be very careful. In a number of situations, I've run into this, and many times in certain industries, you have different investors. For example, in restaurants and hotels, each property could have different investors, and so that you could have maybe 50 or 60% common ownership and not 80%, and you participate under one welfare plan, you've created a MEWA. And in that situation, there's different filing requirements. You have to file a 5,500, you have to file an M1, and again, you have to look at state law where you're operating to see what additional requirements you have. All right, let's look at the disclosure requirements. One of the big things that ERISA does, it puts a number of different disclosure requirements on employers. So these are different disclosure requirements. You have summary plan descriptions, summary of material modifications, summary annual report, summary of benefits and coverage. There's a requirement to provide copies of documents upon written request, and also another right that employees have is you have to make documents available at the principal office of the employer. Which plans must comply? Every employee benefit program, and this includes small employers. So even if you have less than 100 employees, you have to provide a summary plan description to the employees. Are there any exceptions? Yes, there's employer-provided daycare centers, welfare plans for select a group of employees, executives, and again, this doesn't apply to any plan that's considered to be a fringe benefit plan like cafeteria plans. But again, I just want to warn you, there's no small plan exception. Every employer has to provide for this. Now, who has to be responsible for complying? And this is the biggest misconception people have. It's not the insurance company. It's the plan administrator, and many times that's the employer. Who must be furnished an SPD or SMM? Generally covered participants, but not the beneficiaries. Exceptions, the following must receive a copy, corporate qualifying beneficiary, anyone who's subject to a qualified medical child support order, a spouse or dependent of a deceased participant who's still participating, and representative or guardians of incapacitated persons. And then we're talking about an SPC, a summary of benefits and coverage. Generally, the SPC must be distributed to all applicants who's eligible for the plan. Not people covered, but somebody who could be covered. That's a major difference between that and an SPD. When it must be provided? Well, in regard to the SPD, it must be provided within 90 days of a newly covered participant, within 120 days of new plans, and then individuals must get updated SPDs every 5 to 10 years, depending on how many changes they were. Now, again, many employers don't understand this, that what you have to do is not just make the plan available, SPD available, you must provide it. So it must be furnished in a way reasonably calculated to ensure actual receipt of the material. Must use a method that is likely to result in full distribution. So it can be furnished by mail, it can be hand-delivered, but you have to receipt of that. An employee has to sign it, and then you can provide it through electronic means. Now, you got to be very careful with electronic means. You can either send it through email or post it on a website, but again, that only applies to those individuals that have access to a computer. If some of your employees don't have access to a computer, then you must either mail it or hand-deliver it to that employee. Now, there's a general format and style requirement. It must be in such a way it can be understood by the average individual. So it must be written in a manner understandable by the average plan participant. It cannot be misleading, misinformation, or failing to inform participants and beneficiaries. And any description of exceptions, limitations, reductions, or any restrictions of plan benefits must appear in the SPD. You must be informed of what your limitations are. So here are the different items required in a welfare plan. You must have information identifying what the plan is, who the plan administrator is, who the fiduciaries are. All that's got to be described. You must describe eligibility requirements, describe the benefits, describe any situations that may result in loss or denial of benefits, describe the plan amendment and termination provisions, describe subrogation. In those situations, if they get paid because of injury and you paid them, what responsibilities they have to pay you back, and information regarding plan contributions and funding, information regarding claims procedures, model and statement of ERISA rights, prominent offer of assistance, explanation of plans, policy and recovery of overpaid benefits, explanation of allocation between insurance refunds and similar payments, and the fact that the plan administrator has discretionary authority to interpret plan terms. It goes on, detailed description of group term, benefit provisions. This is under a group health plan, description of the role of health insurers, description of claims procedures, provider discounts, incentives, COBRA, and other federal mandates have to be included. Now, another item that's very important is called a summary of material modifications. If you have changes to plan, and this is very common with welfare benefits where things are changed almost on a yearly basis. Technically, you don't have to give an employee a whole new summary plan description. You can give them something called a summary of material modifications. Now, you have to report significant changes. You have to describe them in detail. Must be furnished with 120 days after the end of the plan year in which the change was adopted. For group health plans, it must be 60 days within the change. But basically, ERISA does not require a certain form, and you have to describe what that change is. So in this regard, and this is another important slide, the SPD will generally control if it conflicts with the plan documents. Even if you have disclaimers, courts have said, nope, I'm sorry, this is what you gave to the employees, so this is control. So you have to be very careful to make sure whatever you give to the employees in the SPD kind of gels with what you have in your plan documents. So some courts accept some substantial compliance with format and content, but again, if you don't describe the limitations in detail, there could be possible liability for additional benefits. There could be possible fiduciary breach violations. And you have to be very careful on how you word the documents because there could be a failure to comply with understandable and other format requirements. So there's no specific penalties for not complying with these requirements, but there's general penalties in not complying with ERISA. So there's general ERISA enforcement requirements. Possible criminal penalties for welfare failures of $100,000, prison up to 10 years. And if somebody requests documents, you don't comply them, you could be hit with $110 per day after not complying within 30 days. Now, generally, in my experience, the DOL will not apply these penalties unless they're up against the wall and the employer just ignores them. I think if many times they just ask you to comply, if you're not complying with this, then they won't impose these penalties right off the bat. Other disclosures, again, there's a written requirement, written request requirement, what must be provided, additional copies of SPDs, plan documents, and contracts must be provided within 30 days. If you don't comply, it's $110 penalty per day, but in order to enforce that, they have to go again to federal court, so very rarely is that imposed. Another requirement that documents have to be available for inspection at the principal office of the employer. So again, employees can look at other documents, can look at contracts, can look at various things that you have to provide benefits. Other disclosures, there's summary of annual reports. Basically, it summarizes the information on the 5500 that must be provided within 9 months of filing the Form 5500. And there's a format that's in the regulations. So again, this is something that has to be provided to the employees. SPCs can be provided either in paper or electronic form. The summary of benefits and coverage are limited to not more than 4 double-spaced pages. They can be provided electronically. Both participants and beneficiaries have the right to receive one, and a single SPC can't be provided to the whole family. Now, insurers must provide SPCs or summaries to employers upon request. In general, you have to give it out every year at open enrollment. If there's a change in any information, it has to be an updated SPC. And then when the SPCs have to be provided automatically to the individual enrolling in the plan within 30 days, prior to the enrolling, within 6 days prior to effective date any significant change, and within 7 days when an individual is required to request the document. So these are times you have to provide the SPC. And again, this was employers must provide the SPC at the beginning of the first day. This has been required since 2012. And again, a separate SPC must be provided for each benefit package, but under the law, with the new employee, you have to give an SPC to each benefit package, a medical package that you offer. Ongoing forward, an open enrollment, you have to give the employee just a copy of the SPC that describes the benefit they enrolled in the prior year. And these are the requirements that have to be included in the SPC. And again, the government has provided a template that you can fill in, and the insurance companies do that. Now, also, just remember there's civil penalties. A civil penalty of up to $110 a day if an SPC is given. An excess of $100 per day for effective individuals. For violations of content not formed, it could be $1,087. And you have to self-report any penalties in a Form 8928. Now, reporting requirements. Again, the plan participant must file a 5500 for each plan that they have. Now, there are certain exceptions for certain plans. A complete exemption for small unfunded plans. Plans must be fewer than 100 covered participants at the start of the plan year. So you have to look at, and that it's not employees, it's covered individuals. So again, this is now just remember, there is a proposal to eliminate this exception. Well, that will not kick in until 2018 or 2019. And one thing to note here, the penalty used to be $1,100 a day. Just recently, in August, they upped it to $2,063. The penalties are cumulative, which means it applies each year. And another thing to remember, there's no statute of limitations. So it's important to understand and look and see when you have to file these. The penalties are rather severe. Now, there's a delinquent filer program, which I've used a number of times. If you haven't filed your 5500, you can use that. It's a very simple program. You just basically file it to an address of the DOL. You file one copy at this one address, and you normally file your 5500s. And the maximum penalty could be as low as $4,000. So again, you haven't filed your 5500s. I suggest very strongly use this program. It's called the Delinquent Filer Voluntary Compliance Program. And again, the program imposes the following penalties. For large plans, it's $4,000 multi, and I've filed them for 10 years, and I've only paid one penalty of $4,000. How many forms are needed required? One Form 5500 may be used for multiple ERISA benefits, and that's why, again, some employers are using the wrap documents. It cuts down the filing in this situation. So it's due by the end of the 7th month. You can extend it by filing a 5558. It's automatic. What must be filed? Well, generally there's a Form 5500. A Schedule A is for the insured contracts. If you have plan assets, you have to file a Schedule C, and if you're funded, you have financial schedules. It cannot be filed on paper. It has to be filed electronically. Claims procedures. ERISA requires that plans must establish and maintain procedures. If you are insured, the insurance companies will handle these procedures. So again, you have to make sure they follow these procedures. And what's important here, a claimant must exhaust plan procedures before filing suit. So again, if the insurance company is not up to speed on this, you have to make sure they are. Claimants can skip procedures and go directly to court if there's noncompliance. Courts may apply a lesser differential standard of review, and the claimant's deadline for appeal may be told if, again, everything is not meeting the requirements. Now, here, the basic structure for claims procedures, a claim for benefits to an authorized individual, then the benefit determination and required notification, and there's appeal, and then a determination of the appeal and a required notification of that appeal. Many times insurance companies will have more than one level of appeal. That's fine. So procedures can vary depending on the type of claim involved, and it's the plan administrator that's responsible for complying with these procedures. So the claim must be in writing. The claim must be processed with certain guidelines. There's certain guidelines under health, disability, and other, and there's certain notice requirements. These are the guidelines and when the claim has to be decided under the law. It depends if it's an urgent claim, urgent care claim, it's within 72 hours. Pre-service claim before any services are provided within 15 days. Post-service, it's within 30 days. Concurrent claim is as soon as possible. Disability claims have to be decided within 45 days. Other claims within 90. All adverse determinations must be in writing. You have to explain why they denied it, describe any additional information required for the claimant to appeal, and they must describe the appeal procedure. So a statement that a copy of the internal rules or guidelines relied on can be requested, and a statement of a written explanation of any scientific or clinical judgment. So the appeal must be filed within 180 days. If no appeal, the claimant loses the right to go to court. Once the appeal is filed, the claimant must receive a full and fair review by named fiduciary. So this is an individual other than the one that decided the first claim. And the claimant must be permitted to submit written comments. So again, the appeal must be in writing within specific timelines, must be and contain certain specified information. So, and again, when there's an adverse determination, this is what has to be included. Basically, they have to explain why they denied the appeal, a statement of the claimant's right to obtain relevant documents, a description of any additional required or voluntary appeals, and a statement that a copy of the internal rules or guidelines relied on may be obtained. So, I mean, all this has to be in writing. This is the timelines for deciding appeals, and very similar to what you saw with the initial denial. Now, in addition, under healthcare reform, what this slide explains, after this is done, for medical claims, there is now a new, following the final internal adverse benefit determinations, there's external review. While the state external review requirements have long applied to many group health plans, they can apply to self-funded plans. Self-funded plans in particular, the external review requirement constitutes significant new administrative compliance. Insured plans offering group health must comply with the state external review process. And self-insured plans must meet the federal external review processes, and the DOL has provided interim enforcement safe harbor for self-funded plans. So once that's, the individual can go to an external review after the plan is finished. Now, what's the consequences of non-compliance? ERISA penalties, employee confusion, participant lawsuits, denied benefits, and bad press. Now, a very common question I've been getting is how long you have to keep documentation. This kind of summarizes under ERISA 107, you have to keep it not less than 6 years after the Form 5500 is filed. So I tell people you have to keep records at least 7 years. And this requirement applies even if you don't file 5500s. So you have to keep records at least 7 years. Who must maintain records? Those persons who have reporting or certification requirements. Applies to any plan administrator, insurer, TPA, or CPA. And again, these rules, again, apply even if you don't file a 5500. You must keep records significant to verify the information on the 5500. Records are subject to rules that are defined broadly, include claims records. So again, anything dealing with claims or eligibility, again, must be kept. Are there any questions?
We don't have any.
Amanda, do you have any questions?
We don't have any written, so I'll unmute everybody so they can ask.
I know I covered a lot of material, but
The
do you have
conference
any
has been
questions?
unmuted.
Do you have any questions?
I do.
Yes.
Do you know if level funding is considered, for the purposes of ERISA and 5500 filing, is it considered self-funded?
Yes. Level funding
But
is a form of self-funding. I can't understand why it's considered self-funding, but it is. Because it looks and smells like an insurance contract to me. But the powers that be considered self-funded. So you only have, if you're under 100 participants, you only have to file a 5500 if you set aside assets in the name of the plan. If you're unfunded, which means you pay benefits out of corporate assets, and you're under 100 participants, you don't file a 5500.
Right, but they're over, do they have to do, if they're over 100, do they have to do all those additional filings for?
Well, the only time you have to do additional filing, you have to file the 5500, but if you don't have plan assets, then basically you don't have to file any of the financial information because you don't have any plan assets. So again, you have to file the financial, but if you, and the Schedule C is only required if you use plan assets to pay for plan expenses. If you don't have plan assets, you don't have to worry about that. So basically what you have to file is a Schedule A for the stop loss and the 5500. Now, you have to look at also whether an audit is required too, but since you don't have plan assets, look and see if an audit is required.
Okay, so basically it's just the Schedule A for the stop loss insurance.
Right.
Okay.
Anything else? Anybody else? Okay.
So I have, I guess,
everyone-
one more question.
Oh, sure.
If you have, like you were saying, multiple employee benefit welfare plans, and you do that RAC document, that allows you just to file one 5500 instead of multiple.
Correct.
Okay.
Correct. And again, it's a very easy way of cutting down your work.
Mm-hmm.
Okay? Well, everyone, thank you very much for your time. If there's no more questions, I appreciate it. We'll see you in 2 weeks, and we'll be talking about HSAs. So take care, everybody.
Thanks so
Bye-bye.
much.